Identifying what assets are excluded from probate can be a tricky issue that the executor or administrator must sort through. The default rule in Georgia is that all assets are probate assets unless there is an exception. As a result, the personal representative must understand what those exceptions are and how they work. My name is Eric Broll, and I'm the founder and CEO of Georgia Probate Law Group. At our firm, we help families who have lost a loved one navigate the complex and confusing legal process so they can make sure the estate is handled properly and their loved one's memory is honored. Everything discussed in this video is for general information and is not legal advice. For specific information about your situation, please contact our office to set up a consultation. Non-probate assets are not considered assets of the estate. That means that the non-probate assets are not governed by the probate court and are not managed by the personal representative. As a result, the recipient of a non-probate asset cannot be forced to use the non-probate property to pay creditors of the estate. In addition, the non-probate property is not subject to the terms of a will. The rules governing non-probate property have several key effects. First, even if the estate has far more debt than assets, the non-probate assets will not be affected. Second, non-probate assets are protected from a year support claim, which is Georgia's version of spousal support. Finally, non-probate assets go directly to the designated individual regardless of what the will may say. An asset will usually be considered non-probate property if it has a beneficiary designation, a pay on death designation, a transfer on death designation, or if it is owned as joint property. As a result, each asset will need to be investigated individually to determine if it meets the requirements to be considered non-probate. A few examples of property that is usually, but not always, non-probate are life insurance, retirement accounts, certificates of deposit, jointly owned bank accounts, and jointly owned real estate. Remember that if the title or beneficiary designation is not set up properly, then the asset will likely revert to being a probate asset and will not be considered to be part of the estate. I would caution you to investigate each asset and not make any assumptions. In our office, we have seen it go wrong too many times when clients have made assumptions without proper investigation. If you would like more information about this and other probate topics, please go to our website and download a complimentary copy of our Georgia Probate Handbook. Our website is www.gplg.com, and I have included a link in the description below. As always, thank you for watching.